Waitip. Hello, everyone. Hello, everyone online. This is Devin Doss, your Vice President of Guest Relations with the TRU Faculty of Law Podcast. And today we're going to be talking about tenancy law. Today we've got a special guest, Tara-Lynn Wilson, who's with us from Forward Law. And she's actually an alumni with TRU and was one of the Indigenous valedictorian for the class of 2024. I will pass it over to you, Tara, and introduce yourself to folks online.
Hello, everybody. My name is Tara-Lynn Wilson. I am Secwepemc on my mother's side from close by here, Bonaparte, and I am also Hanuksila on my father's side, and that one comes from Kitimat, which is 13 hours north of here. And like you said, I'm a recent graduate of TRU Law. Main areas of focus that I like to look into is Aboriginal law and criminal law. Also, like what you said, I am currently articling with Forward Law under David Hughes. I'm here only to provide legal information, not legal advice. So if anyone has specific concerns, I urge you to seek out legal advice.
Thank you so much, Tara. We are honored to have you here with us. My name is Ishaan Kapoor, and I am the Vice President of Research with the TRU Law Podcast. I'll be starting us off with a few questions about tenancy law today. So today we'll be talking about key rights and legal processes for tenants, maintenance, repairs and rent increases, privacy and landlord access, ending tenancy and eviction, dispute resolution and legal support, and general questions on student-tenant protections. So the first question that we would be asking you is, what are some basic tenant rights, such as protection against sudden eviction or rent hikes?
The first one would be the right to quiet enjoyment. And so tenants have the right to enjoy their rental property peacefully without interference, and that includes interference from the landlord in any way. So they also have the right to safe and habitable housing. Basically, what that means is that the rental unit must meet basic health and safety needs. Next, they also have the right to dispute problems. So the tenant has the right to apply for a dispute resolution with a residential tenancy branch and have their issues heard by a third party. They have the right to access the rental unit. So a tenant cannot be locked out of a rental unit. It's actually illegal for a landlord to lock them out of their unit. Next, they also have the right to not be physically removed. So a landlord cannot physically remove a tenant from the unit or take any of the tenant's personal property without a court order.
All right, that was really insightful. Thank you so much for that. I would also like to follow up with another question, which would be, can a landlord legally evict a tenant and what notice must be given?
There are conditions for legal eviction, and there could be reasons like non-payment of rent, breach of the tenancy agreement, landlord's use of the property, renovation or demolition, substantial damage to the property, health and safety violations, if it's the end of a fixed term tenancy, and if the landlord ends up selling the property. Although these conditions, although they may make a lawful eviction, there are certain procedures that the landlord must follow in order for it to be considered a lawful eviction. One of which is giving a notice to the tenant if they want to evict them. So for most evictions, landlords must provide a written notice to the tenant that includes specific timelines depending on the reason for the eviction. And the notice must clearly state the reason for the eviction and the date the tenancy would end.
Thank you so much for that. Our listeners would also like to know what happens when disputes arise between tenants and landlords.
So if a dispute arises, the tenant can file an application with the residential tenancy branch. There is a $100 filing fee for filing that kind of application to submit the application. But under certain circumstances, you can actually request that that fee be waived. If the issue is particularly complex, the tenant should seek legal advice to find out what their rights are related to their specific case. There are places in Kamloops that provide free legal advice, and one of them is here at TRU, they come from TRU Law, and they're known as the TRU Legal Clinic.
Thank you, Tara, and thank you, Ishaan, for leading out those questions. I had no idea that folks could access dispute resolutions, nor did I know about those fees. Hopping into the next set of questions here, we're going to be talking about maintenance and repairs, as well as what to look for when rent increases. So the first question here, Tara-Lynn, what are the legal responsibilities for landlords and tenants regarding maintenance and repairs?
Landlords are responsible for maintaining the rental unit in a habitable condition, and making necessary repairs. They must also respond to maintenance requests in a reasonable time. As for tenants, they're responsible for keeping the unit clean, reporting maintenance issues, handling minor upkeep, and they're also responsible for paying for any damage that's caused by their own negligence. Tenants must also allow landlords access to the unit for repairs, given that the landlord has provided any kind of proper notice.
All right, thanks for that. And this next question, so how often and by how much can rent be increased, and how can tenants dispute an unfair increase?
Landlords can actually only increase the rent once every 12 months, and they must provide tenants with at least 3 months written notice before they can actually take that or make that increase, before it kind of takes effect. The amount of the increase is actually limited to a percentage set by the government each year. And this year in 2025, the rent increase limit for residential tenancies is actually 3%.
I like that you covered the landlord needing to provide notice to enter the suite. This next question kind of correlates to that. So, beyond all these financial concerns, another issue that folks might see and be frustrated by is privacy. So, how much control do tenants have over access to their rental unit?
So, like I explained earlier, tenants have a right to quiet enjoyment. And what that means is that they have the right to enjoy the rental unit peacefully and without interference. A landlord's unlawful access to a unit can be a breach of that right. A landlord can only enter the rental unit under specific conditions and must provide 24 hours written notice, unless they're entering for stuff like an emergency, so the protection of a life or the property, or if they're entering with an order from the residential tenancy branch, or in the case of an abandoned rental. So if the tenant just leaves and abandons the rental, then they have the right to enter the property. But other than that, they have to give 24 hours notice. And if the tenant is present, though, then the tenant can actually give a verbal permission to the landlord, but that is not required. So the tenant does not have to say, yes, you can enter, but they're allowed to say that.
Great. Thank you, Tara-Lynn. Very, very good points there.
Right, thank you so much. Moving forward, if a tenant feels unsafe or uncomfortable and they want to end their lease early, what options do they have?
That depends on the kind of lease that they have with their landlord. So if it's a fixed term lease, meaning a contract that is for a specific time, like a specific amount of time, so it ends at a certain date, then the ending of the tenancy would be considered breaking the agreement. And the tenant may be required to pay the landlord money up to the amount of what they would have paid in rent if the agreement was not broken. A fixed term tenancy cannot end early without penalty unless both the landlord and the tenant agree in writing, or if there's a special circumstance as to why the tenant needs to leave the unit then. Also, if it's ordered by an arbitrator from the residential tenancy branch. So if they're feeling unsafe, then that's kind of where that falls into, but they would have to get that agreement in writing with their landlord if they do want to leave their lease early. But if it's a month-to-month lease, then what you could simply do is just end the tenancy by giving 1 month's written notice, and that has to be given before the day your rent is due. Let's say that you pay rent on the first day of the month and you want to move out by January 31st, then you must give your landlord notice on or before December 30th.
Thank you, Tara-Lynn, for answering those questions. I'm really glad that we're actually filming the tenancy law closer to the end of the semester because I'm sure most students listening online here, roommates don't work out, landlords don't work out, whatever the situation is, we're approaching that time where all of this information is very relevant to us. So moving on to the next question here, even when properties change hands, tenants may still have rights. So how does the new law protect them?
In the sense of a personal use of eviction, personal use includes the landlord or a close family member of the landlord. And this is where some people kind of get confused when they go forward. So if the landlord wants to evict a tenant so a close family member can live in the unit, the close family member would have to be the landlord's spouse or the parents or children of the landlord. You can't get evicted if your landlord wants to move their cousin in. It doesn't work out that way. They have to be specific people within the landlord's family in order for that to be a valid eviction.
I actually had a question there. So I noticed, Tara-Lynn, you mentioned landlord's spouse and parents of the landlord's spouse. Can you dive into that a little bit deeper?
If we kind of break it apart so it's a little bit easier to kind of understand, is that the Residential Tenancy Act, they define what a family member is. And for one, it's either the landlord's spouse, like I was saying, or the second one would be the parents or children of the landlord, or the parents or children of the landlord's spouse.
Okay. Thank you for that.
Thank you, Tara and Devin. I would like to dive into bad faith evictions and what protections exist to address this.
Well, landlords are not allowed to end tenancies unless specific legitimate conditions are met, reducing the likelihood of any kind of unlawful evictions. And landlords are required to use generated notices and receive director authorization for certain evictions. And that's ensuring that landlords cannot evict tenants without proper documentation or oversight.
Tara-Lynn, tell me, how do updated rules on rent control when adding roommates benefit student renters?
Landlords are prohibited from increasing rent if additional occupants are minors, or if they were minors when they started the tenancy. This kind of thing, it helps with financial stability for students who may need to accommodate others during their studies, or for students that plan on moving their children and family in with them. It prevents landlords from imposing additional financial burdens on an already competitive rental market.
Yes, very competitive Kamloops is. Wrapping up with a few more questions here. So what important contract clauses should students review, such as terms on rent, repairs, notice requirements?
So students should pay close attention to clauses regarding rent and payment terms. So you want to look for the due dates and the acceptable payment methods. So if your landlord wants you to e-transfer your payment or if they want it in check. Next, you want to look at the security deposit, how you need to pay it and how it's handled and how it will be returned to you after the tenancy is over. Repairs and maintenance, so landlord's obligations to necessary repairs and the process required for requesting repairs from your landlord. Next, you want to look at the notice requirements. So the notice, if you want to give a notice for either the ending of a tenancy or a landlord visit, you want to look at what that notice needs to be, what it needs to say, and when it's required. You also kind of want to look at if there's subletting and roommates that are allowed. So some tenancy agreements do not allow subletting or roommates to be entered in. And if they are, then it's good for you to take a look at that agreement to see if what is allowed and what's not allowed, and if there's a consent process, if there is allowed to be a subletting or roommate. And then you want to look at the eviction terms, so kind of the reasons why the evictions would be taking place. And then finally, you want to look at the renewal and termination of the lease. So if you're on a fixed term lease or a long-term lease, then when the lease is over, does it automatically convert to a month-to-month, or does there need to be a notice provided by you, or if you need to provide a notice to move out or renew.
All right, Tara-Lynn. So wrapping up here, I just want to say a huge thank you for your time and out of your day, especially because you're at Forward and you're doing your thing. So yeah, I just want to say thank you.
Thank you, Tara, for being here. It was a pleasure having you. And I hope our listeners are enlightened by your knowledge.
So thank you for inviting me, and I had a lot of fun.
And for our listeners online, be sure to check out our Instagram page, Spotify. That's where you're going to find all of the information for upcoming events on campus, new episodes. So check us out. Thank you. And until the next episode, see you again.